Ottoman Studies. İlber Ortaylı. The family in Ottoman society. A few words are called into order to explain why our title is The Family in Ottoman Society, rather than one such as the Ottoman family. Closely related to this point is the impossibility of basing the study of the family and marriage in Ottoman society on explanations derived from textbooks of Islamic law, fiqh. Both these approaches, namely the use of the concept of Ottoman family and the interpretations based on textbooks of Islamic law, have been quite commonly utilized by those who have already written on the subject. This does not mean, however, that they have any explanatory value. Whichever sociological classification one adopts, it does not seem possible to specify an, quote, Ottoman family, end quote, as a separate category, and evaluating or defining this family in the light of the fundamentals of Islamic fiqh and the information contained in the books of jurisprudence does not seem feasible given the nature of Islamic law. The basic sources for investigating problems such as the family and women in Ottoman society should be the Qad registers belonging to the various periods and regions of the empire. Travelogues round second in importance. Finally, we may also utilize the accounts found in certain chronicles. As in all traditional societies in which the family is the basic economic unit, the extended family was also the predominant type in Ottoman society. This extended family was embedded within a still larger collective social unit in which 3 generations coexisted and which included the families of brothers and other close relatives. This was the case for both Muslims and non-Muslims Ottomans. According to the Ottoman tax registers, the unit called hane, household, consists of 5 persons on the average, but it would be erroneous to suppose that the household corresponds to an independent family in each case. More commonly, households belonging to the 3 different generations of the same family lived as one economic unit in homes arranged around a courtyard. Again, this entity would usually be compelled by close relatives living in the same quarter. This is why a quarter in a typical Ottoman city was not just an administrative unit, but also a close-knit community composed of relatives who always stood up for each other. Together, the individual members of the extended family comprised a unit of production. This was true for urban artisans as well as for peasants who made up the vast majority of society. In all cities in which impersonal institutions have not yet emerged, members of the family and near relatives form the basic matrix of social relations which surrounded the individual from birth to death. Security rests with the kingship group to which the individual is connected, and he lives for his family. As with all traditional societies, nepotism also defined the sum total of human relations into which Ottomans of all classes were born and in which they existed to the end. Thus, childbirth is an event which is celebrated throughout the entire quarter as well as within the family and with which interests everyone living there. This new addition to the community is welcomed through a specific rite called Lohusa Hamame. Another rite, the Amen Alayi, is effected when the small child is starting school. When the same child has successfully mastered reading, he is paraded through the quarter and applauded. Weddings, becoming a parent, etc., are all occasions of great interest, first for the family and then for the quarter. The extended family produces and consumes jointly. Nurturing all members of 3 generations, its women sew together, prepare and store winter food in common, visit together and entertain themselves as a group. The men of the family buy food together, build and do repairs for the extended family as a whole. The nuclear family usually does not live as an independent unit. Husband, wife, and children do not have the time and energy to devote to their own narrow family. Time and urbanization, of course, inevitably contributed to transforming this kind of family and relations in the Ottoman society as elsewhere. The Istanbul family in the 19th century, for example, with which we are quite familiar through literature, although still different from the modern family, clearly reflects a basic transformation of old family structure. Residential districts of Ottoman cities were demarcated and molded not along economic but religious lines. Non-Muslims settled in a narrow belt on the fringes of the town would carry on their lives in much the same fashion within the framework of relations structured by their own extended families and communities. And in many other traditional societies, interdenominational marriages were very rare. Although religious law allowed Muslim men to marry non-Muslim women, it should be borne in mind that non-Muslim congregations also strove very hard to prevent such marriages. In certain regions, the Muslim officials or merchants posted there did marry Christian women temporarily, but this was also quite uncommon. Contrary to what is usually supposed, polygamy was not very widespread in Ottoman society. Even some European travelers noticed as much. Salomon Schreiber, for example, a German Protestant priest who passed through Turkey towards the end of the 16th century, noted that, quote, Turks rule countries and their wives rule them. Turkish women go around and enjoy themselves much more than any others. Polygamy is absent. They must have tried it but then given up because it leads to too much trouble and expense. Divorce is rare, for then the man has to pay in money and goods and daughters are left with the mother. End quote. The woman is in fact the most important member of the traditional family, but her status both there and in society in general does not measure up to her role in production. This standing is nevertheless enhanced with age and increasing number of children. Naturally, I am not going to claim that women were free in traditional society. Any approach to this question from the standpoint of our present system of values would neither be appropriate nor necessary. And of course, we cannot really speak of the freedom of men in such a society either, because they, too, did not take part in the process of production of their own free will. But the woman's dependence on the male member of the family extended beyond marriage, and she was in the position of a factor of production transferred from one family to another. The value paid in exchange for this transfer, variously called bashlık, kalem, or some other name, is contrary to what is usually supposed, not peculiar to the Ottoman Islamic society. For the mehr of Islamic law, paid in two parts, is a payment appropriated by the woman herself and as such constitutes some sort of economic security for her in the case of divorce or widowhood. Payments like bashlık, kalem, etc., on the other hand, have nothing to do with principles laid down in legal fiqh texts. In all traditional societies where women marry young into economic dependence, it is the custom for the groom to make such a payment for his bride. General characteristics of traditional agrarian societies clearly can be attributed to the specificities of neither Turkey nor the other Islamic Arab societies. Therefore, the topic should be dealt with not from a narrowly legalistic viewpoint, but also more broadly within a sociological perspective. Only in this way can the relationship between legal codes and actual social practices be clarified. The customary explanation, then, is that the Turkish bashlık payment or the sadak, its Arabic counterpart, are extensions of the Islamic situation of the mehr. But bashlık and sadak have been present in the Orient from time immemorial, undergoing a very little change through the ages down to the modern era. Such customs have also served again and again to establish legal precedent. Marriage, involving the payment of bride price, has evolved naturally in the course of civilization as the transition from matriarchy to patriarchy deprived women of their equal status in matters of marriage, divorce, and inheritance, and eventually put them in the position of being given in marriage by their father or other kin in return for a payment by the groom. The new family formed under these circumstances is inevitably patriarchal and agnatic throughout the world. Before Islam, marriage customs revolving around the payment of bride price as mer or in some other forms were already prevalent among the Arabs. Such traditions reflect a patriarchal polygamous family structure. The pre-Islamic mer was the purchase price for the woman. The Muslim religion, however, subjected this existing custom to new adjustment and constraints. Most importantly, it forbade the bride's father or other king from appropriating the mer and left it entirely in the hands of the woman to be given in marriage. It is difficult to say that these Islamic injunctions have been universally or rigorously obeyed. It was always possible for ancient practices or deformations of new ones to spread from a wide under the force of socio-economic circumstances. As noted above, Islamic law demands that the mer be paid in two parts. There is the mer-i muakshel first, and then the mer-i mueshel, to be paid out of the inheritance in case of divorce or if the husband dies. In order for the act of marriage to be formalized, the bride must have assented publicly that the mer has been paid, and this must have been duly recorded in court register. There is a disagreement among Islamic jurists as to what the minimum mer should be, but 10 dirhams of silver seem to have been the most common. As the mer belonged to the bride, neither her parents nor her husband could force her turn it into add to her dowry. Nevertheless, comparison of such injunctions of Islam canon law with actual practice in Ottoman society does reveal certain conflicts between custom and the letter of the law. Many entries concerning marriage recorded in the Kadı registers of 16th century Ankara, Cankiri, Kayseri, and Konya, for example, do not fit the requirements of any of the four Orthodox Sunni denominations on the subject, indicating that marriages practiced in Anatolia in that period did not always accord with Islamic regulations. In the light of such documents, it should be useful in this article basically devoted to family relations, marriage, divorce, extramarital affairs, in Ottoman society to compare from time to time actual observed practices with the principles of Islamic law. We know that in the Ottoman Empire, canon law Sher-i hukuk was largely replaced by customary law, Orfi hukuk, in the public field and especially in the area of land tenure. Conversely, it is often repeated that what we would today call the realm of private law was left to the Shariat. We are, however, unable to share this view since the abundance of observable practice in violation of the Orthodox Shariat shows that in familial matters like marriage and divorce, legality extended way beyond the articles of canon law. Apart from the accepted domination of customary law in the fields of administrative and criminal law, it seems possible that further researchers into family law might also uncover rich examples of non-canonical procedures, such divergences from religious principles usually being caused by the influence of local and custom tradition. In the district or province to which he was appointed and where he would remain but a short time, the typical Ottoman Kadi refrained from strict implementation of standard legal rules and regulations. For him, it was better to conform to local traditions than to disrupt that local order and perhaps make way for chaos. Ottoman jurists never tried to go beyond loyally copying the works of classical Islamic jurists when it came to writing a treatise concerning familial relationships. They were not nearly so orthodox, however, in actual practice. Thus, traditions such as Başlık and Kalın were legally validated by courts in central Anatolia in the 16th-17th century, and when it came to trying cases of adultery or divorce, Ottoman lawgivers once more proved more flexible than the harsh clauses of Islam. But one should not exaggerate. In the Qadi registers we have cited, records conforming to the Islamic principles on mehr are numerous as those that do not. Marriage, for example, was in all places recorded at the court register. It seems that this practice was indeed very widespread. Otherwise, the man and woman concerned would be summoned to court for cohabiting out of wedlock, and their illegitimate relationship would duly recorded at the same register. On the other hand, as Jennings had observed in the case of 17th century Kayseri, in at least some localities, the so-called Ottoman family was founded on the separation of property rights for husband and wife. But the best examples of custom conflicting with the Islamic rules on marriage are to be found in central Anatolia of the 16th century. Thus, on the basis of several entries in the Ankara court registered for that period, it would seem that certain type of betrothal called namcillik, literally candidacy, was quite common. The father would promise his daughter in marriage to someone while she was still very young and would accept money or goods in exchange. This sum would then be consumed by the father, and he would not hand his daughter to the man to whom she was betrothed when she finally came of age. Cina olmama is the term employed in the Qadi registers to denote real separation of a married couple or the fact that their joint existence has come to an end. Contrary to orthodox practice, in some places the wife who had left her husband home would not be required to return. Such a woman might instead forego her rights to the mer-ir muachel and to alimony. A woman stated to be henceforth divorced by her husband was required by canon law to wait at least 2 months before remarrying, and it seems that this particular injunction was commonly observed. Payment of alimony would be decided by the court on the woman's application not just in case of formal divorce, but when and if the husband simply left the house or failed to provide for his family. As in all traditional societies, extramarital relations and bearing children of uncertain fatherhood were severely frowned upon by 16th century Ottomans. The namus, the Turkish word of honor, which, however, is just one of its meanings, derives from the Greek nomos, should perhaps be sufficient indication of how universally prevalent attitudes were in this respect. 16th century Ottoman society had nevertheless moved away from the much harsher punishments imposed by ancient Oriental societies for such practices. According to the Islamic law, for example, any adulterers, upon proof of her, quote, crime, were liable to be stoned, in accordance with a provision adopted from Old Hebrew law. But even in the earliest period of Islam, provisos were added which must have made inflicting this punishment all but impossible. That adultery had in fact been committed had to be proved through the testimony of at least 4 male witnesses, and the woman accused by her husband of adultery could evade punishment by denying the allegations and basing her denial on a solemn oath. This particular ruling was commonly adhered to in Ottoman jurisdiction, where Qadis generally refrained from deciding that, quote, adultery had been formally proved, end quote. When residents of a quarter surprised a couple having an illegal affair and paraded and ridiculed them in the streets so as to bring them into court, the verdict would usually be one of, quote, alleged adultery, end quote, and a prison term and/or condemnation to the galleys would be imposed. Throughout Ottoman history, there was only one instance where rekum, or stoning, was decided upon and carried out. This happened in a period of extreme religious fanaticism, and it encouraged such opposition that it was not repeated. In 1680, a woman living in the Aksaray district of Istanbul, whose husband was away at war, was accused of having been caught in the act of adultery with a non-Muslim youth in the silk trade. The verdict of the court was rekum for the woman and death penalty for the young man. Kashakşehir for Rumelia reluctantly assented, and the entire affair was much resented by the ulama. The penalty was not repeated. On the other hand, women who bore illegitimate children or cohabited out of wedlock were never regarded with tolerance, and urban security officers were empowered to keep an eye on them. In the late 16th century, of such women would be immediately placed in the custody of the subashi in the provinces, and efforts were made in Ottoman cities to keep unmarried men out of their residential districts. Even in Istanbul, that megalopolis, in the influx of single men looking for work would be channeled to special inns in the central industrial district and quartered there under some sort of surveillance. The transformation of family structure. The last century of the Ottoman Empire was one of reforms, the main purpose of which might have well been, as is commonly asserted, the modernization of the army. However, it does not seem that the statesmen of the 19th century were aware of the necessity of a thoroughgoing modernization in the financial, judicial, and administrative spheres as well. These 19th century reformers wanted a regime where the law was supreme. Social change, once it sets in, inevitably affects areas and aspects of society well beyond those for which it was initially intended. Hence, European civilization gradually but surely became the model not only for the army, administration, and finances of Ottoman society, but also for its culture, literature, and daily life. The Tanzimat period was a time when a new type of Ottoman person began to emerge. 19th century Ottoman society was obviously not yet in the throes of really radical fundamental change. However, the onset of a certain modernization in practically every field remains hardly disputable. And it was a time when significant changes also began to be felt in the life of Ottoman women whose existence took on a different hue. We should not suppose that this new coloration consisted solely of following the fashions, of differentiation in consumption patterns, of learning a foreign language or playing the piano. In other words, that it was limited to the superficial tastes and behaviors of everyday life. In fact, the classical structure of the family in the rural countryside, as well as in the larger cities, came increasingly under pressure of certain structural changes in agriculture and education in Ottoman territories throughout the 19th century and the eventual arrival there of the products of the global revolution in communications and technology. Finally, it should be noted that the problem of women's liberation occupies an important place in the Near Eastern modernizing ideologies of this period. From the Islamic modernists to the liberals, practically all thinkers in the region advocated changes in the classical family structure and in the social status of women. As recent historical research into demographic movement in the Balkans has demonstrated, the Rumelian provinces in the 19th century were the scene of developing commodity production for export to West European markets in both agriculture and semi-finished manufacturers. This led to considerable urbanization, which in turn implied the initiation of a modernization in family structures. In Anatolia, too, an important turning point of Turkish social history was beginning to take shape. Forced sedentarization of tribes in the Çukurova, Antik, and Maraş regions, meant a new life for this previously nomadic population. Then, towards the middle of the century, the emergence of a class of agricultural wage laborers, first in the Aegean region and then in Çukurova, in connection with the spread of monoculture, cotton, lent further impetus to the transformation of the rural family's mode of existence and structure. Yet another factor was the Land Law of 1858, which was promulgated to put new legal shape on the classical system of land tenure and that had long been undergoing dissolution, and to promote the spirit of private enterprise in agriculture. While it is hard to say, on the one hand, that it effected a very rapid and efficient transition to private property, or that it really helped to consolidate small and middle farming, the code also undeniably introduced some innovations in the tenure of and inheritance of agricultural land. We are not going to analyze the land law here in detail, except to the point that the issuing of title deeds for lands that had been held and exploited by custom, by turning them into inheritable property, inevitably started the rural extended family down the path of eventual breakdown in conjunction with another important legal measure, the granting of equal inheritance rights to female children, acting as an additional accelerator. The new system of land tenure must have quickly made itself felt in regions with technically modern agriculture and developed commodity markets. Quantitatively, these 19th century changes in the agrarian economy would certainly not stand comparison with the great transformation Turkey experienced in the 1920s and especially in the 1940s. Nevertheless, they clearly represented the beginning of something qualitatively new. Another qualitative change observable in the 19th century was in the migration from rural areas to large cities like Istanbul, Beirut, and Salonika. Whereas previously only unmarried men would move to the big towns and at least some would stay there only on a seasonal basis, migrations of entire families began around this time. And in Istanbul, in the vicinity of the Golden Horn, close to the city walls, the first squatter quarters came into being. It would not be an exaggeration to call these first signs of urbanization and a transition to the nuclear family. The socio-cultural changes of the Tanzimat period constituted a golden age which introduced at least upper and middle women to social life. While Islamic modernists came up with new interpretations of the Sharia to justify abolishing or at least restricting polygamy, other thinkers and authors in both Ottoman territories and other Near Eastern countries, as well as on the periphery of the Russian Empire, were directly campaigning against the traditional type of marriage and family structure. Thus, Ibrahim Shinasi Bey somewhat naively satirized these antiquated customs in his Shair Evlen Messi, our first modern play. The founder of the dramaturgy of Azerbaijan, Mirza Fethali Ahundo, and his followers also radically criticized in their works the sequestered existence of Muslim women, the patriarchal family setup, and the ignorance to which female children were condemned. In the 1880s, a group of women from among the Muslims of Russia started a women's journal called Alei Nishvan to spread the first feminist movement. And of the most important undertakings of the Tanzimat era in education was to provide schooling opportunities for girls by creating the intermediate level Inas Rushdilire. As the number of girls' schools increased and they came to include high schools or lycées by the end of the century, a new professional group arose, female teachers. That the initial entry of women into working life in Turkey took place in the field of education before the entry into industry partially accounts for the relatively strong position of women in the contemporary Turkish bureaucracy to this day. The new intelligentsia which emerged out of the intellectual ferment of the Tanzimat period included women of upper class, Fatma Aliye Hanem, the daughter of Chejbet Pasha, being their prototype. In the larger cities, women had broken out of the confines of their homes, and their visible presence in many types of social activity, ranging from moonlight excursions on the Bosphorus to shopping in Pera, made a Tanzimat statement such as Chejbet Pasha, anxious about the increase in womanizing and in immorality. In short, despite the slowness of industrialization and urbanization, Turkish women may be said to have entered a phase of moderate liberation in the 19th century. In newly industrialized Europe, women had paid a very high price for their liberation and encountered new difficulties in social life. A similar process is just beginning for the women of this society. But because of the difference in the general circumstances, the price paid by Turkish women for their liberation is probably not as high as paid by their European counterparts. These different circumstances derive from the reforms in recent Turkish history, which prepared a suitable ground for the liberation before industrialization. Statesmen of the Tanzimat period were aware that the existing family code and marriage customs were creating problems. Plans for legislation to cope with this date as far as the attempt by Ali Pasha to adopt French civil code. But since the level of social development had not permitted this, only certain decrees and edicts to bring traditional marriage under some control could be produced. As investigated by S. Turan, these decrees and edicts basically attempted to prohibit payment of bashlik for marriage and to curtail great expenditures in general. Thus, a firman of May 1844 ordered that 1. Daughters of age should be allowed to marry of their own free will without any interference from their parents, and that 2. Payments such as bashlik, being declared illegal, not be rendered to bride's parents. 18 years later, on 23 Rebu level 1279, 8 of September 1862, the governmental edicts in the connection with the implementation of said firman were issued. 10 articles in all. They prohibited extravagant weddings and the payment of bashlik, while setting the amounts of meri muechel and merhi muechel at 100 kurush, 500 kurush, and 1,000 kurush for the poor, the middle, and the rich classes, respectively. The very poor would pay nothing. All this was intended to make marriage easier. The edicts further abolished the custom of presentation of gifts by the groom to his bride relatives after the wedding. Weddings were also classified as first, second, and third class types with the legal amount of expenditure for each category specified carefully. These edicts clearly resemble the law number 55 dated 1336, 1921, quote, prohibiting extravagant expenditures at weddings, end of quote, adopted by the government and the Grand National Assembly during the Liberation War. That decree and the edicts obviously did not do away with customary practices overnight, but we must allow that they represented a certain progress. As is well known, the Metchele, which was an important 19th century legal compilation, does not include articles on family law. Nevertheless, the decree and edicts mentioned above do indicate that the tendency to modernize marriage and the family was gathering momentum. At least among the urban population, ancient customs and polygamy declined during this period as a result of economic and social necessity. In the second constitutional period, modernist ideological and political trends continued to focus on marriage and the family. There were polemics between administrators, lawyers, and thinkers on this subject. A novelist of the time elaborated on the problems of Turkish womanhood in a rhetorical and didactic manner. Ziya Gökalp, the master theoretician of the Committee of Union and Progress, was drawn to this question in his youth and even wrote a short story titled Ibish Dai, satirizing traditional marriage. In this general climate, one would have expected the young Turks in power also to undertake certain innovations in the realm of family, and in fact, the Turkish hearths were hotbed of feminist activity. But the Union and Progress government was unable to make radical moves in this direction in its dictatorial phase after the Balkan War, and then again during the Great Conflict of 1914-1918. In fact, those very government circles and Enver Pasha were busy trying to cope with the popular discontent of the squalid years of war and defeat by appeasing reaction. In this context, a special commission was even created to specify charshaf, length and standards of veils for women. For all these reasons, the Decree on Family Law of 1917, which had been the status of law, did not introduce any deepening reforms. It has, however, considered binding for all Ottoman subjects regardless of religion, and in this respect, it was the first standard legal text of its kind in any Islamic society. The decree lent women some protection against divorce and polygamy, and it imposed state supervision of marriage for Ottomans of all religions. While not going into the content of this decree on family law in any greater detail, we should point out that its claim of regulating marriage and family law for all Ottomans equally was somehow damaged by the exceptions granted to non-Muslims through some of its individual articles. Suffice it to say, then, that this never fully implemented decree law had a very short life, being abrogated in June 1919. It must have pleased neither fanatical Muslims nor these non-Muslim clericals who were afraid of losing jurisdiction over their respective congregations entirely. The daily life, socio-cultural behavior, earnings, and consumptions of typical families belonging to the various strata and regions of Ottoman society have yet to be researched intensively, especially for the 19th century, in which social change accelerated. Such research should be based on combing a limited number of memories, births and deaths, registries which to be sure are not very orderly everywhere, and travelogues as well as literary works such as novels and short stories. Those of Hüseyin Rahmi, Gurpinar and Ahmed Rashem, for example, as well as scenarios of Meda, traditional mime, acts are of no small importance for an understanding of the way ordinary folk lived in that century. Of all Near Eastern countries in the past 100 years, Turkey has undergone the most rapid economic change, to which not only purely agriculture and industrial growth, but also legal and socio-cultural reforms have made an important contribution. Gaining an understanding of the transformation of the family had gone through in the context of contemporary Turkish modernization may therefore be said to acquire some universal significance. Today's Near Eastern Islamic societies survive on lands which witnessed the earliest agricultural revolution in history, and therefore also the rise of the oldest urban communities. On the other hand, they still have not completed their industrial revolution and entered the stage of modern metropolitan life. By contrast, Europe and North America possess very brief pre-industrial histories. Hence, in investigating the family as well as many other institutions of these Near Eastern Islamic societies, the dichotomy to keep in mind is not that between Islamic society on one hand and modern society on the other, but that between underdevelopment metropolitan society on one hand and developed metropolitan society on the other. It is our opinion that the seemingly different structural characteristics of the Near Eastern family should be therefore attributed to the heritage of an exceptionally long pre-industrial history of social development.